name is Sallie Sanford, and I'm an associate professor at the University of Washington School of Law with an adjunct appointment at the School of Public Health. California versus Texas was heard before the Supreme Court on November 10th, 2020. And in this case, the challengers argue that the individual mandate to the Affordable Care Act is now unconstitutional, and therefore the entire wide-ranging law must be thrown out. In 2012, the Supreme Court ruled that the Affordable Care Act's individual mandate is within Congress's power to impose taxes. But then, in late 2017, Congress zeroed out the tax penalty. Shortly thereafter, a group of states filed suit, arguing that the law now lacks a constitutional underpinning. Now, for issues, there are three key issues before the Supreme Court. The first is standing. Do the parties have standing to challenge the law? The second is the constitutionality of the mandate. And the third, if they decide that the mandate is unconstitutional, whether it is severable from the remainder of the law. No. So if the Supreme Court rules that the individual mandate is no longer constitutional, then it will get to the severability analysis. First, the Supreme Court could decide that the individual mandate is fully severable from the rest of the law. You just take a big black pen and cross it out. Alternatively, the Supreme Court could decide that it is bound up with other parts of the law, of the statute, such as the pre-existing condition protections and other insurance regulations. And then the question would be, which pages of the law are thrown out? Finally, of course, the Supreme Court could decide that the entire law must be thrown out. This is probably the least likely outcome, but it's certainly possible. It's hard to overstate how disruptive and destructive it would be if the Supreme Court threw out the entire Affordable Care Act. So by most estimates, about 20 million people would lose their health insurance in short order. And this relates to two central and also expensive parts of the Affordable Care Act. The first is its expansion of Medicaid to cover Americans who don't have employer-provided coverage and who make at or around the poverty level. And then secondly, the Affordable Care Act regulated and subsidized the individual health insurance market for people above that level of income. And many of them, if not most, would find it difficult to pay their premiums without the subsidies. Right now, the Affordable Care Act remains the law. It's been a remarkably resilient law. And we are now, in November of 2020, in the midst of open enrollment. So those who don't have health coverage through their employer can go to a website and see what their options are. In Washington State, it's wahealthplanfinder.org. And then for the rest of the country, you can go to healthcare.gov and be directed to the appropriate website. It's also important to know that regardless what the Supreme Court decides, healthcare access and affordability are likely to be dominant issues for the foreseeable future.